All right. I think we're going to get going. So hello to everyone. We've got nice people from all over the place. Sunny Oxford. I hope that's correct. Rainy Greece, Portugal, Spain. Well, nice to have you all here. And yeah, we'll get started. I'm sure a few people will join us as I do the introduction, but that's fine. So hello, my name's Chris. I'm the director of Statewatch. Thank you all very much for coming and for taking time out of your day to attend this webinar. As I said, I work for Statewatch, which is a charity based in London, concerned with civil liberties and state powers in the fields of migration, policing, surveillance, criminal law, prisons, and other related issues to do with the coercive powers of the state. And we undertake and encourage the publication of investigative journalism and critical research in those fields with the aim of informing and empowering individuals and other civil society organizations to engage with and take action on civil liberties and justice and home affairs issues. This webinar is also hosted by the Transnational Institute, who are helping us with the technical side and various other things. TNI is an international research and advocacy institute committed to building a just, democratic and sustainable planet. And for over 40 years, TNI has served as a unique nexus between social movements, scholars and policymakers. And needless to say, both Statewatch and the Transnational Institute very much welcome the support of individuals who appreciate their work. And you can donate to both organizations via our websites. So thanks for coming. This is the third and final webinar in our series looking at the report Deportation Union. This report we published in August, which turned out to be very timely, really, given the announcement of the new pact on migration and asylum, which, as I'm sure many of you are aware, covers all manner of topics in the fields of migration, asylum, border controls. And for our purposes, it also has a significant emphasis on stepping up removals, returns, deportations from the EU, however you wish to call them, and expanding the role of Frontex, the EU border agency, in the EU's border control and migration and asylum regime. So I'm just going to start by giving you a brief overview of the report. You should obviously read it, but it is quite long, so very much appreciate if you haven't had time to do that yet. But that's what the Christmas holiday is for. So the report gives an overview of what we see as the expanding European Union deportation system. Decisions over immigration and asylum cases, individuals' cases, remain in the hands of the member states, but the machinery for enforcing those decisions is increasingly a matter of EU law and policy. And so the report looks at three main areas. The first is the Returns Directive and the ongoing attempts to recast or rewrite the Returns Directive. That's a piece of legislation that governs the majority of forced removals from the EU. And the renewed version is still under discussion by the European Parliament and the Council. And following the publication of the pact, there's now heavy political pressure on both those institutions to adopt it as soon as possible. And the key point we make in the report is that the recast version, as proposed, and without many of the amendments proposed in the Parliament, will lower or eliminate many legal protections for individuals who are facing removal proceedings. The second part of the report looks at the EU databases and information systems that are used for deportation proceedings, and it looks at those in the context of what's known as the Interoperability Initiative, which seeks to join up existing databases, adds more data to them, and wants to make more information available to more authorities. And we look at the new types of data that are going to be gathered and made available to the authorities for use in removal proceedings. Both those topics were dealt with in previous webinars that TNI and ourselves hosted. If you couldn't make it to those, you can also watch the recordings online. And the third main section of the report, Deportation Union, looks at the topic we're here to discuss today, and that is the role of the EU Border and Coast Guard Agency, which is better known as Frontex. So it looks at the different types of operations that the agency can conduct, the new powers granted to the agency in the legal reforms in 2016 and 2019, and some of the issues and controversies that surround the agency's role in forced removal operations. And as I'm sure many people are aware, there's recently been a lot of public discussion about that agency's alleged role in or knowledge of pushback operations at the Greek-Turkish border, and its accountability for that. And there's also been ongoing controversy about the actions or inactions of the agency and its staff during removal operations, mistreatment, wrongful removals, abuse which has gone either unreported or not been dealt with adequately or sufficiently by the agency or national authorities. So that's what we're here to discuss today, how this all works, how the agency is held accountable or not, and certain initiatives to try to ensure greater respect for human rights in forced removal operations. So today we've got three excellent speakers. We're very pleased to have them all with us. And they're going to give their presentations. We can take a few brief questions after each presentation, but there's also going to be time for further questions and discussions at the end after they've all given their talks. If you have questions for the speakers, please submit them via the Q&A function in Zoom. Hopefully everyone is a Zoom Pro by now, but that can't be taken for granted. I've been on this thing for 9 months and I still don't know what I'm doing. But there's a Q&A button at the bottom, and you can submit questions in there and we will go through them and try to get answers for you. So today we're going to be hearing, as I said, from three speakers. We have Andreas Pottakis, who's the Greek Ombudsman with us, Mariana Gkliati, a researcher at Leiden University, and I'll give a bit more of an introduction to them before they speak. But first we're going to go to our first speaker, which is Jane Kilpatrick, who has been a researcher at Statewatch since April 2019, and is working primarily on our project, EU Justice and Home Affairs Agencies, Accountability, Transparency and Fundamental Rights, and is leading our research into Frontex. So without further ado, I will pass over to Jane for her presentation.
Cool. Thank you very much, Chris, and thank you everyone for coming today. It's great to see lots of you in the audience. So I will look at how Frontex's role in deportations, as well as deportation's role in EU migration policy, have grown and continue to grow since the publication of our report in August. I'm sure lots of you will be aware that it's been quite a controversial and busy time for the agency since then. I will do this broadly by looking at some of the situations that we do describe in the report, and considering what's changed since then and what that might mean for the future. So before I do this, I'll just give a really quick summary of the different types of return operation that might get mentioned a lot today, as they can be quite confusing, and there's a lot of terminology that Frontex use that we get very used to using as well without really clarifying what it might mean. So these are national return operations, which is where just one EU member state will have an operation to deport people to another state outside of the EU, so not involving any other EU member states. Joint return operations are, they've been in Frontex's legal mandate since its foundation in 2004, and these are where a member state organises a return flight and has the capacity to include people being deported from other member states as well. So it can invite other states to fill those spaces, as it were, by communicating that to Frontex, who can then dispatch the information to other member states. There are also collecting return operations, which is where the means of transport and the escort officers on board a return flight or return operation will be provided by the non-EU state of destination where people are being deported to. In those situations, people are transported from various EU member states to an organising state, and from there, deportees will board a flight or other transport that's been organised by the collecting state, and escorts on those operations are trained by Frontex to comply with the EU standards, including on fundamental rights, and all collecting return operations must have a monitor present to monitor fundamental rights. Another term that's used very often and perhaps in a slightly misleading way is that of voluntary returns. The European Council of Refugees and Exiles have phrased this slightly more fittingly as mandatory returns rather than forced returns. but EU institutions and Frontex use the term voluntary return to refer not to someone who's made a genuine voluntary choice to leave the country they're in, but to people who have been issued with a deportation order, but who have the option to choose when and how they can return to their country of destination. So yes, thanks Jess for starting the slides. So the first two slides that I have are in the report, and they were made by Chris very well. And those are really just to give a bit of context. Firstly, in terms of how low the proportion of return operations are actually conducted by Frontex. So in the first of the two slides, looks at return decisions, and then how next to that, quite a low proportion of those in theory are actually enacted, and then a very small proportion of those are actually deported on Frontex operations. So it's just worth remembering that this is just a section of deportations. It's not the whole picture of the EU's deportation machine. So a very quick recap as well of Frontex's shifting role. Oh yes, sorry, and the other slide is of the countries, the EU states that most frequently use Frontex return operations and the states to which they most frequently deport people as well, just for some context. So a quick recap of Frontex's role in the area of deportations and how this has changed and developed. The 2004 founding regulation gave Frontex the mandate to assist in the organisation of joint return operations, to finance them and to identify best practices in obtaining travel documents for people issued with return decisions. The 2011 amendment to the rules extended these powers so that Frontex could coordinate and organise joint return operations, finance those operations with its own budget and other EU funds, and it included the option to charter aircraft to conduct return operations. So using an aircraft that has no other passengers on it, it's used solely for the return operation. The 2016 European Border and Coast Guard regulation centralised returns as one of Frontex's core tasks, allowing it to provide states with information about countries of return, to provide assistance on how to implement returns procedures in accordance with the Return Directive, and to advise and assist with the implementation of measures to prevent returnees from absconding. And then the 2019 regulation entered into force now just over 1 year ago. The proposal for this regulation prioritised the stepping up of the effective return of irregular migrants and called for a strengthened and fully operational European Border and Coast Guard to do this. The extended powers from the 2019 regulation brought aspects of the entire removal procedure into the agency's remit. And this included analysing information on countries of return, acquiring travel documents, including by means of consular cooperation, organising and coordinating return operations, providing assistance with so-called voluntary returns and assisted voluntary returns, and providing assistance to returnees during pre-return, return-related and post-arrival and post-return phases. The intention of all of these new powers, this has been very openly stated by the Commission and reflected in budget proposals for Frontex under the EU's new 7-year budget proposals, and through the increased budget allocated for returns under Frontex's new regulation, is an increased Frontex mandate for the coordination of returns from member states, with a stated goal to deport 50,000 people a year in the next 7-year period. And then in September, we see that this is also alongside measures such as the Commission's proposal for a new Frontex Deputy Director for returns responsible just for that part of the agency's operations. The European Parliament's Civil Liberties Committee conducted a visit to the Frontex headquarters in February this year, and the mission report published in July discussed Frontex's increased role in the area of deportations, and also revealed that the agency will be collecting statistics to inform the implementation of the new visa code in order to impose certain restrictive measures against third countries who do not cooperate with the EU in the area of readmission. So this shows sort of this growing ambition for the agency's role, not only in the operational side of deportations, but also in this sort of policy background side, collecting and analysing and using information to drive what operations are planned as well. So in the report, two novelties of the 2019 regulation were examined. So those are voluntary returns and post-return assistance. And those are areas which have been changing this year since the entry into force of the 2019 regulation. So a new feature of the 2019 regulation includes technical and operational assistance related to voluntary returns, including implementation of assisted voluntary returns. So yeah, as I said, Frontex has been exploring this new role in voluntary returns, and so have EU institutions and member states, which is clear from the emphasis on voluntary returns in the Commission's proposal for a new pact on asylum and migration in September. According to a Frontex internal report circulated to government delegations in March, since the entry into force of its new mandate, Frontex has been providing technical assistance for so-called voluntary returns, with the first two carried out on scheduled flights in February this year. So that means that people were returned on flights that were also used by the general public. So this wasn't a charter flight used specifically for this purpose. So the slide that is up now was provided, it's information provided to Statewatch by Frontex, just demonstrating what countries have mainly been using this option through Frontex, where people are being so-called voluntary returned to, and the number of flights used to deport people in that way by Frontex since the start of 2020. So as well as conducting these flights, Frontex is also developing a module in its application for returns dedicated to organising voluntary returns by charter flights as opposed to scheduled flights. And on top of this technical support delivered by the agency, there are also plans for the provision of on-the-ground support from Frontex representatives who will be part of the new standing corps that's planned from the start of next year. So if all of that seems like quite a lot of new activity, it's still worth remembering that the European Council and member states seem to want even more than this from Frontex. Member states have listed the following areas under voluntary return in which they would find Frontex support helpful. The creation of a common European database on third country nationals who have received voluntary return and reintegration support. Excuse me a sec. The development of a reintegration assistance tool, and the evaluation and research programs on voluntary return and reintegration. The Frontex internal paper from March this year also sets out more specific goals for voluntary removals and how it's going to take over the management of the currently nationally coordinated European Return and Reintegration Network. And in this report, they also highlight plans to deploy an increasing number of liaison officers for return to countries including Gambia, Egypt, Somalia, Nigeria, and Ethiopia. And then just finally on the note of this European Return and Reintegration Network, it's interesting to bear in mind that the European Council presidency believes that the transfer of this network to Frontex will also involve support to unaccompanied minors being returned. And it's worth remembering there that currently Frontex rules do not allow for the deportation of unaccompanied minors. And the agency's consultative forum on fundamental rights is very insistent that this remains the case, but certain states do want to use the possibility of using the Frontex application for return system to book flights for unaccompanied minors. So that is an area worth keeping an eye on in the future. So related to voluntary return is this option of post-return assistance, though that shouldn't be limited to those who use the voluntary return option. Post-return assistance was very well explored by Jill Alps in our first webinar in this series, who really depicted the situation faced by many people after they're deported, which can often be very untenable and dangerous. And the 2019 Frontex regulation includes the provision of technical and operational assistance to post-arrival and post-return activities of the member states. The Civil Liberties Committee mission report details that new work is foreseen for the agency in supporting the integration of returnees in their home country after they've been deported, though the committee also emphasised that member states' expectations in this area may be higher than the agency can deliver. According to the report, post-arrival assistance will require substantive resources that might not be provided by the forthcoming EU budget. However, I don't think it's too controversial to suggest that it's up to the agency to allocate within its own budget enough to ensure that its operations, such as returns, do not put individuals in danger. So if it is conducting return operations and not providing post-return support, I think that is an issue of concern anyway. Yeah, so those are two kind of novelties introduced in the 2019 regulation, but there have also been ongoing issues which remain live. So issues raised in the report Deportation Union about, for example, the inaccessibility of Frontex's individual complaints mechanism and the risks posed to fundamental rights during Frontex operations and insufficient external scrutiny are all still ongoing in 2020. I think this is particularly well illustrated, as most of you will be aware, by the numerous publications in recent months by journalists exposing evidence that suggests Frontex knowledge of and possible participation in illegal pushbacks from Greece to Turkey in the Aegean Sea. In response to these allegations, Frontex established an internal management board working group to investigate, which surprised no one when it apparently found no evidence to substantiate claims of violations of the law or Frontex code of conduct. In a hearing held by the Civil Liberties Committee, MEPs demanded a greater degree of transparency and democratic accountability than that is offered by an internal Frontex mechanism. Yeah, and I think all of these kind of ongoing and new issues kind of demonstrate a pattern in which member states or the Commission or Frontex itself have certain ambitions for the agency beyond what Frontex can actually deliver or beyond what is within or doable within fundamental rights requirements. So just to illustrate this in one last point, I'll just consider one final situation from 2020. The proposal for the 2019 regulation sought to allow Frontex to carry out expulsions from one non-EU state to another. For example, deporting someone who was from Afghanistan, from Serbia to Afghanistan, rather than from an EU country. Despite strong support from some member states, such as Hungary, Poland, and Slovenia, this was entirely removed from the text following opposition from the European Parliament. But some developments from 2019 and 20 do suggest that this kind of externalization of deportations is still on the agenda. The first of these is to do with the EU's status agreements with certain Balkan states on Frontex activities in their territory. But the one I will focus on, as I do not have much time, is actually more recently the increased arrival of people to the Canary Islands and the EU's response to this. 7 Frontex officers have been deployed in Gran Canaria to support national police in identifying people on the islands. And there have also been some deportation flights since the end of last year, some of which were funded by Frontex. These return flights involve the return of people who are not of Mauritanian nationality to Mauritania, which is permissible because of a 2003 agreement between Spain and Mauritania, which allows non-Mauritanian citizens to be deported from Spain to Mauritania if they went through Mauritania in order to get to Spain. So there is still some Frontex involvement in this sort of chain deportation. And some concerns have been raised by the Spanish Ombudsman and the National Committee for the Prevention of Torture over irregularities and human rights concerns in these flights funded by Frontex, one of which being that 4 of the people on board from Mali were from regions deemed unsafe by UNHCR in terms of security and humanitarian situation. Yeah, so those are just some general pictures looking at changes in the new legislation, changes since the new legislation, and certain concerns that are still unclear at the moment. So I think that's all, and I'll leave it there. Thank you very much.
Thanks very much, Jane. That was an extremely useful and comprehensive overview of something which I'm sure everyone will agree is, well, large and complicated. But I think as that shows us that, you know, the role of the agency has grown enormously in the last 3 or 4 years, and there's a strong political desire to increase it even further. We do have a couple of questions here. Two from Isabella, who was Isabella Maiko, who was one of our speakers in our first webinar in this series. So I'm just going to take one of them for now. Maybe we can come back to one of them later. Isabella asks, do Frontex's monitors accompany every flight, one per flight, or do they work in parallel to monitors from contributing states? I don't know if you have the answer right there, Jane, but that's a question from Isabella.
Yeah, I have I'll probably need to check my answer, but as far as I understand, not every Frontex flight is monitored. I think they've been fairly open about the fact that they haven't been able to monitor all the flights when they've said that that's an aim. Collecting return operations are all monitored, I think, which is in the report that we published. And so far, Frontex can request monitors from a pool of monitors from member states' national competent authorities. So in a way, that's a slightly more external or independent monitoring mechanism, and it's actually Frontex's only external monitoring for any of its operations is this return monitoring. But there still are concerns that Frontex funds their activities while monitoring the Frontex operation. They can only report on the state that has requested them. So for example, in a joint return operation, if France has requested a monitor, the monitor will only be able to submit reflections on France's conduct, not any other state participating. And Frontex still selects monitors to go on each flight or operation. So there's still their national monitors, which are independent of Frontex, but their participation is still dependent on Frontex's money and choosing them, I think. And I'm sure actually probably Andreas would have a much better overview of that, but maybe we'll wait for his talk.
Yeah, thanks very much. I should say that we do set some of this out in the report, Deportation Union, the number of flights that have been monitored over the last decade and a half or so, and it has increased gradually, but not to the extent that is desirable. We do have a few more questions in here, but in the interests of time, I will save them until the end. So please keep putting them in there, and I'll bring the questions back up when we come to the end of the session. So yeah, I think on the issue of monitors, it's this is a sort of fundamental part of the ensuring the accountability of removal operations, and that's the question we're going to turn to now. We have Mariana Gkliati with us, who is a researcher at Leiden University. She was also one of the co-authors of our report. She specializes in human rights protection in Europe, forced migration, refugee law, and European migration law. And her PhD looks at the legal responsibility and accountability of Frontex for human rights violations. She teaches on the master's degree in refugee protection and forced migration studies at the Refugee Law Initiative at University of London and at the Migration Law Clinic at Roma Tre University. And she's also undertaken, provided advice, training, and research for a number of national and international NGOs. So I will now hand over to Mariana for our next presentation.
Thank you very much. And thank you, Jane, for providing a very clear framework, which leads very well to what I have to say about the responsibility of the agency. So Jane also spoke of the accusations of pushbacks in Greece and the discussion regarding the possible engagement of Frontex therein. And of course, I'll be happy to discuss the developments regarding that during the discussion. But for now, I would like to turn the focus to returns in Hungary and discuss that during this presentation. So basically, this is happening while the agency experiences a broad expansion of its powers and competencies with the last amendment of its regulation in 2019. And I will first give you a quick overview of this this expansion, also taking into account the new EU Pact on Migration and Asylum, as it was presented last September, so that we can have a more general overview, a more general impression of what we can expect to see in returns in the coming years. So basically, returns, deportations are one of the main elements of the pact, along with the new border procedure and the reformation of the arrangements on responsibility sharing. One of the main changes brought by the pact is that the return procedure is now joined with asylum determination. A return decision will be automatically issued upon a negative asylum decision. And as a result, we can expect that the examination of the risk of refoulement, the best interest of the child, and protection of family and private life will not be extensively examined. The return decision will be prepared by Frontex. However, the agency may not enter into the merits of such decisions, which will be ultimately approved by the member state. A second major change concerns the extended period of detention. After the return decision is issued, the migrant will be deported within 12 weeks. During this period, they may be detained. If we combine this with the proposed maximum of another 12 weeks of detention during the examination of the asylum claim, the process can result to up to 6 months of detention at the external borders. And now, in this regard, we need to also take into account a worrisome development that was already present since the 2016 recast proposal of the Returns Directive, which contains a very broad list of reasons that can justify the placement of a person in detention. This concerns the interpretation of the risk of absconding. So basically, the risk of absconding is, with that proposal, far more broadly understood and in a mandatory way for member states. And since also alternatives to detention remain rare, a prolonged detention now becomes the norm. We can note also a third major change in the introduction of return sponsoring as a form of solidarity from one member state to another in case of migratory pressure. Now, when we have migratory pressure is determined by the Commission with the support of the EU Asylum Agency and Frontex. In this case, the option is given to member states to support other member states at the external borders, either by allowing the relocation of a denied asylum seeker to their territory, or by sponsoring the return to the country of origin. The sponsor state can then offer support in carrying out the necessary activities for return, including organizational and financial support, and taking care of all the necessary arrangements to carry out the return. Of course, those of you that are already familiar with Frontex will notice that this role, that the agency already has this role. It organizes and carries out such return operations from member states. Now, with the return sponsorship, the Commission introduces a procedure that is coordinated autonomously by member states and that will work in parallel to that of Frontex. This procedure will lack the fundamental rights safeguards that, even though inadequate, as we're also going to talk about shortly, are still, though, present in Frontex operations. In an attempt to manage this confusing picture in returns, the pact also calls for an EU return coordinator supported by a network of return representatives from the member states. Finally, the pact calls for further engagement with third countries to achieve their cooperation in readmissions. It envisages a much deeper involvement of Frontex in forming and supporting new partnerships with third countries. The Commission wants the agency to make this cooperation operational. With the pact, the agency is also called to specifically appoint a deputy executive director for return. Now, more generally, the Commission announces a leading role for Frontex on returns and wants it to become the operational arm of the EU return policy. This was already made clear in the 2019 amendment of the agency's regulation, and the expanded mandate that it received in returns at that point also indicate that. And I will now get to the main changes of the 2019 regulation. And now that we're getting to the proposals, from the proposals to what the law actually is, I would like to share some slides with you. I hope that you can see this. Okay, so basically, overall, Frontex has acquired greater autonomy and operational effectiveness with the 2019 amendment of its regulation. The main framework for the operation does not change fundamentally. The host member states are still primarily responsible for the border surveillance operation. However, the agency's powers and capabilities are now significantly enhanced. The three main changes brought by the 2019 regulation are the standing corps of 10,000 border guards, the expansion of mandate and returns, and the explosion of its budget. And I will get to each one of them. So first, we have the establishment of a standing corps of 10,000 operational staff with executive powers comparable to those of the border guards of the member states and the return specialists of the member states, since we're talking about returns. This standing corps now includes the agency's own personnel. The second main change concerns returns. It's a major enhancement in the agency's return competencies. The new regulation makes returns a key priority for the agency, which experiences the enhancement in pre-return and return related powers. Amongst these is that the agency can now operate with its own return escorts and return monitors in its own vessels, in its own aircrafts, initiate operations unprompted, and also prepare the return decisions themselves, as we said. While it also has enhanced data management capabilities. I'm not going to talk about them at length at this point, at least. The third major change is the expansion of the agency's budget. All in all, the proposed EU budget for the period 2021 to 2027, so for the whole EU, foresees tripling of funds devoted to migration and border management with almost 35 billion euros. Almost one third of the whole budget on migration and borders goes to Frontex. Frontex now receives around 11 billion for this period 2021 to 2027. This is, of course, in conformity with the progressive growing of the mandate of the agency every year, as you can see in this table I've prepared. But it is the first time that the agency's budget is counted in billions. There's always been increase, but since 2019, it's quite significant. From this amount, almost 1.8 billion euros goes to returns. This is an increase close to 300% since 2018, since the last year. And also this calculation excludes the significant envelope for the acquisition and maintenance of aircrafts and vessels. That is separate, that's 2.2 billion. All this, of course, contributes to the priority goal of intensifying returns. The intention proclaimed by the Commission in 2019 is that Frontex facilitates the return of 50,000 persons each year. And this is, of course, a quite ambitious plan. And of course, returns are always more difficult than they sound. But let's get into the more specific situation at the Hungarian-Serbian border that has caught the public eye quite a bit less than the pushbacks in Greece, but evidence there is still equally compelling. So under legislation introducing Hungary in 2015, all asylum applicants that have previously been in a country that Hungary considers safe are automatically rejected without the application of the procedural safeguards required under EU law. Serbia is considered safe, is in this list of safe third countries by Hungary. So everyone that has transited even through Serbia is rejected and expelled. As a result, we have collective expulsions to Serbia, summary dismissals of asylum claims that have also been reported by the agencies own fundamental rights officer and by the Consultative Forum for Fundamental Rights of Frontex by UNHCR, while the EU has also initiated infringement proceedings against Hungary. Already since 2016, the Fundamental Rights Consultative Forum of Frontex and the Fundamental Rights Officer had suggested that the agency withdrew from its operations in Hungary because of the systematic nature of the violations. Their recommendations were rejected by the executive director. He stated then that the allegations were not confirmed because of the very few, we should say, serious incidents reports that had been submitted by the Frontex teams on the ground, and because the Hungarian authorities said that their investigation resulted in finding no violation. He also followed the recommendation of the European Commission in that regard to continue with the operations. The Commission supported then that the presence of Frontex would in fact be beneficial and contribute to the improvement of the human rights situation on the ground because of the agency's monitoring of the situation. We saw, unfortunately, that these hopes did not materialize and the violations have continued. While we also have reports that implicate now Frontex Finnish dog team in allegations of abuse at the border. In 2019, again, UNHCR raised concerns regarding the role of Frontex in the return from Hungary to Serbia of 2 Afghan families without the proper examination of their asylum claim. They were about to be returned in a Frontex flight, and that flight was at the last moment halted by the European Court of Human Rights by interim measures, Rule 39. UNHCR advised Frontex then to refrain and required that directly refrain from supporting Hungary in the enforcement of such return decisions, which are not in line with international and EU law. Now getting to the issue of responsibility as such, can we say that the agency can be held responsible for violations in Hungary? And this, of course, applies to any comparable situation in any member state. First of all, we need to be clear that the ultimate responsibility for violations occurring in any return flight, either to Serbia or to Afghanistan from Hungary, belongs to Hungary itself. And that's the case even after 2019, after the changes in the regulation. The agency may now prepare return decisions, but it may not enter into the merits of the return decisions or the asylum applications, the asylum decisions, I should say. It is still, however, responsible for ensuring compliance with the principle of non-refoulement. Frontex cannot be held responsible for the ineffectiveness or the outright unlawfulness of the asylum procedures in Hungary, but it still has a positive duty to ensure compliance during return operations it coordinates itself. It needs to take all appropriate action to prevent violations, and if it does not do so, the agency risks being found complicit. And to be clear, there are things that the agency can do and that it cannot do. It cannot review and express an opinion about individual asylum applications. It does not have disciplinary powers over border guards. It does not have criminal jurisdiction over them. It does not have civil jurisdiction. It does not also have full control of the operation. It is still Hungarian return operation. But there are still things that it can do to prevent a violation. This ranges from the training of border guards to the instructions that the Frontex coordinating officer on the ground can give to the teams, to the appropriate functioning, very important, of reporting and accountability mechanisms of the agency, and the last resort of suspending or terminating an operation when there are persistent and systemic violations. Both UNHCR and the Fundamental Rights Officer have stated that suspension of operations in Hungary is necessary for the agency to comply with its fundamental rights obligations. Now, what is new after the 2019 mandate expansion? There is an increased possibility for the agency to be found complicit after the amendment is implemented, because it's still not fully implemented. I should say to the largest extent not been implemented. So after it is implemented, there is a greater possibility for the agency to be found complicit, especially since return flights will be conducted in the agency's own aircrafts by the agency's own escorts. So in conclusion, regarding whether the agency could have responsibility, we can say that there is indeed significant room for the responsibility of the agency before even the implementation of 2019 amendments. The agency can be found responsible for aiding and assisting in a violation, either actively through its technical, financial assistance, or by omission, by failing, for instance, to suspend or terminate an operation. After the 2019 amendment, we can note a shift from complicity, from aid and assistance, to direct responsibility. That becomes much more prominent. Now, if you wish to read more about Frontex responsibility in returns and the new mandate, Jess can share with you a free access version of a book chapter I wrote about that, but I will not take more of the time for this. I would like to say a few final words on accountability in order to also leave enough room for discussion. So we see that this mandate expansion, that we see that it has not been matched with an equivalent accountability set of safeguards. We still need to see strengthening of administrative, of political, of legal accountability responses. And the agency does indeed have the potential to bring up human rights standards across all its operations in the EU. It can be become a driving force for human rights across all operations in all EU countries and beyond. And in order to do so, however, it needs to take appropriate strategic decisions regarding its engagement, when to participate and when to suspend, listening to the fundamental rights officer and to the consultative forum. It needs to appropriately follow up on the complaints it receives and the serious incidents reports it receives. It needs to empower in practice the fundamental rights officer and immediately deploy the human rights monitors in all return operations. And it also needs to allow more transparency in its work, including how the serious incidents reports are assessed. Only upon such strong foundations can the agency safeguard itself against complicity and can help in improving compliance in all its operations. And of course, more law is not always the answer. We first of all need to focus on the enforcement of existing legislative framework. That said, there are a couple of legislative changes that can make a significant impact, an immediate impact. And that would be, first of all, ensuring that there is external follow-up of the complaints mechanism by the European Ombudsman. When the former EU Ombudsman, Mr. Diamandouros, when he proposed the introduction of the complaints mechanisms that is now in place, he suggested then that he is the one that looks at the complaints. Now, these complaints also need to be reviewed by the Court of Justice. And as a third change, and with this I will close, what can make a significant difference is the introduction of a robust system of external monitoring of the return operations run by existing bodies with relevant human rights experience. And that can include, of course, the CPT, the Committee for the Prevention of Torture of the Council of Europe, national human rights institutions, and ombudspersons. And I will leave it at that. Look forward to hearing more about that from Mr. Pottakis as well.
Thanks very much, Mariana. That was very useful and very informative. Just a couple of quick questions for you before we proceed. One is really easy. Well, maybe it is, which is from Doreen Johan, who asks, will this presentation be shared afterwards?
Gladly.
So I think we can probably send that to everyone who's here. And we also have a question or a clarification, request for clarification from Sarah Zellner, who asks, could you please explain the legal basis for the agency's role in preparing return decisions? Do you refer to the collection of information necessary for issuing return decisions in Article 48 of the 2019 regulation? as far as I know, the preparation of return decisions has been removed from the final version of the regulation.
The agency is already active at the hotspots, especially since 2011, with fingerprinting and debriefing, identification interviews. So this could be with regard to the information sharing, and this information can certainly be shared. Can contribute to the returns decision itself. Now, we're not talking about adopting a returns decision. That will be preparing the framework, drafting the return decision, and making a first assessment. But that cannot be on the basis only the information that the agency shares. Assumingly, there will be an asylum claim that will need to be dealt by the Greek Asylum Service, for example, or the Hungarian Asylum Service, and then the agency, on the basis of that decision, will assist the member state in preparing the return decision itself. Now, I do not remember the article of the regulation by heart, but I would be happy to share that together with a presentation as well.
Thanks very much. I have to say I'm shocked you can't remember the number of the article. I think we all are. Thanks very much. There's lots of questions coming in, which we will come back to at the end to the greatest extent possible. But immediately we'll come on to our next speaker, who is Andreas Pottakis, who is the Greek Ombudsman. He was elected as the Ombudsman by the Greek Parliament in July 2016, and his term runs until 2022. And in late 2017, he was elected Regional Director of the International Ombudsman Institute, and in 2020 to the position of President of the European section of that institute. And since 2019, he's also served as the President of the Association of Mediterranean Ombudsmen. And his background is in law. He studied at Athens and Oxford, where he was awarded a doctorate in EU public law, and has lectured in the UK, Italy, Turkey, and Greece, where he's also pursued a career as a lawyer before the Supreme Court. And he's published extensively on issues including European public law, comparative law, constitutional and administrative law, and the legal protection of human rights. And in his time as Greek Ombudsman, he's also undertaken some work in particular on forced removals and return operations from Greece and the issues surrounding them. And we're going to hear some more about that now. So Andreas, over to you. Thanks.
Thanks a lot, Chris. Thanks for the invite. And well, actually, thank you for having me placed third, because I'm delighted that both Jane and Mariana preceded me, because I think that most of the issues that had to be somehow presented and explained have already been explained in an impressive detail and accuracy. So I suppose that this makes my job all the more easier, or perhaps poses new challenges to me, so that I remain at the same level as the previous interlocutors. Why am I in this panel? Well, I think that one of the reasons, but maybe Chris can explain with more authority on that. I think that one of the reasons that I was invited is that I represent an institution that has the mandate of conducting monitoring as a national monitoring authority in forced returns. And so I suppose that I would be sharing with you some of the experiences that I have had as the Greek Ombudsman under the special mandate, the capacity that we have to monitor forced return operations, including Frontex organized, coordinated, you name it, operations. I will get into that in a while, but first I think I should make some first preliminary comments. Both Chris, but also Jane and Mariana have used various terms, and it is, I think, it is indicative of the subject matter and the complexity of the subject matter that we are treating. They have used this generic term removals, but they have also used the term returns. I think I have heard readmissions, which relates to the return operations under the EU-Turkey joint statement of 2016. So people being returned from Greece, mainly from Lesbos to Turkey. We have heard deportations, we have heard expulsions, we have heard pushbacks. I think I've taken note of all the different terms that I have heard anyhow. Now, I will be focusing on most of these things because we are monitoring most of these things, save for the so-called voluntary returns, which are not under our remit. We are not, or no national monitoring authority is tasked with monitoring voluntary return operations, so-called voluntary return operations. I emphasize so-called voluntary return operations because I do share the concerns that I think Jane raised as to the extent to which these return operations are truly voluntary or not. Be that as it may, we somehow equate voluntary returns with operations that are, or have been at least so far, been aided, assisted with by the IOM, either in the organizational sort of aspects of it, or by granting sort of subsidies to people and incentives to people, financial incentives to people to be included in the voluntary return operations. I will also not be touching upon alleged pushback cases for obvious reasons. I just want to share with you that my office, the Greek Ombudsman, has instigated a non-initiative investigation on pushback cases since the summer of 2017. We opened up this investigation in light of an alleged pushback that involved the Turkish journalist. I have amended this decision several times since the summer of 2017 in order to include several other complaints, several other allegations of pushbacks. However, I will leave it to this point because I don't want to share with you any of the findings of the investigation because it's an ongoing investigation. Hopefully, though, we will be able to present and to publish an interim report in the very near short future. Not the conclusive report, not the final report, but hopefully an interim report, as understandably it has been already 3 years that we're investigating all these cases, and I feel that we need to report at some point as to what exactly we have been doing all these years. Now, just a quick, a few points on what exactly our mandate is, so as to, give all our participants a general idea of what an ombudsman institution like my office does. First of all, as I mentioned, we are the Human Rights, Forced Returns and Readmissions Monitoring Authority in Greece under the Returns Directive 115, which has been transposed into Greek legislation. We have been entrusted, this means, with the monitoring of forced return operations. Monitoring forced return operations, just to clarify, involves different stages and phases of a monitoring operation. It involves the so-called pre-departure phase, okay, which basically entails an inspection of the places of detention, places where people are being detained in order to be returned or deported or removed. But we are also looking into the files of the people, trying to make sure that to ascertain that their rights have been respected, that the procedures have been, the due process has been followed, legality has been observed, the principle of legality has been observed, and so that they have exhausted all possible means of resorting to either administrative or judicial authorities, especially those who file for asylum, who apply for asylum. And this basically is the pre-departure phase, and then monitors also participate in the so-called actual operation, which means that we are accompanying people who are being returned, who are being removed from the country, alongside their escorts, who are normally police officers, up to the point of the handover to the authorities that they're being returned to, of the country that they're being returned to. I take stock of, I think again, Jane has mentioned something about a reference in the most recent Frontex regulation about enhancing somehow the mechanisms of post-delivery, post-return cooperation with the authorities there. This is something that we have been, as ombudsman institutions, arguing for several years. It is a very complex thing. It is quite complicated. It is quite political, I have to say. But we are waiting to see how the specific reference in the new Frontex regulation will play out, and whether it will be effective enough so as to allow us as well as monitors, but also the national authorities who are responsible for the return operations, to have a clear view of the conditions in which the people who are being returned, the conditions that the people who are being returned are going to face. Now, apart from this, which is a special mandate for the Greek Ombudsman, we are also, as the Greek Ombudsman, we are also the preventive mechanism, the national preventive mechanism under the optional protocol of the United Nations Against Torture, which allows us free and unhinged access to all places of detention, all places of restriction of liberty, including hotspots, including pre-departure centers, and of course, police station detention facilities or detention cells. And we do that regularly and without prior notice, of course. We investigate them, we inspect them, and we report on the findings, and we report on the conditions, at least annually, in an annual report, but also regularly throughout the year. Now, we also have this, what one would call the general ombudsman sort of mandate, which is we are handling complaints. Most often, when it comes to this subject matter, we are handling complaints about asylum applications not having been processed accurately. We are handling complaints about cases of people who complain that they have not been registered appropriately by the authorities upon arrival. And we are handling, of course, also complaints of people who may have an issue when it comes to the conditions upon which they were removed. We also have another special mandate in Greece. We have the mandate of investigating arbitrary behavior of the security agencies. Basically, what we do there is we are quasi-disciplinary body, external and independent disciplinary body for the police, the Coast Guard, but also the prison guards. So we do conduct investigations either on our own initiative, or we are following the investigations that have been launched by the appropriate bodies, the disciplinary bodies of those agencies. And we are again reporting on this annually. And also we have general mandates on equal treatment. We are the equality body of Greece, and we are the so-called children's ombudsman in Greece. So we are also, if I may put it this way, we have a keen interest or more expertise, let's say, in areas of discriminatory behavior or the treatment of minors, and clearly we are sensitized even more so when it comes to unaccompanied minors. Now, just that was the brief overview of our mandates and what general framework within which we operate. Now, it is clear that returns are very high on the agenda of the European Union and the European Commission. Indeed, the pact has come to demonstrate that there seems to be a strong political will within the Brussels bodies to come up with something in order to boost returns. And I would like to submit to you that this should not have come as a surprise, because so far return operations have been not working properly. They have not been very successful. I would only like to share with you a few data. I will not bore you with a lot of data, but I think they are quite indicative of the fact that return operations, the way that they have been being conducted have not been as successful as perhaps the Commission or other EU institutions may have wanted them to. First of all, let me give you the fact that although all these sort of discussions around return operations and enhancing the role of Frontex or of national bodies in order to increase the number of people being returned, of returnees, has come at the backdrop of the 2015 so-called migration crisis. The fact that is that we have had a truly massive wave of third country nationals that have been moving into Europe from third countries in 2015 and 2016. You are very familiar with the various different ways with which the various European Union bodies have tried to address the situation very unsuccessfully. Having said that, though, it seems that the people who are being returned and have been returned in the course of the last few years, at least, have nothing to do with, are very different from the people who have entered Europe in the course of the last 5 years, from 2015 onwards. You may be aware, I'm sure you're aware, that most of the people who have been moving into Europe from 2015 onwards have come mostly, at least in the first couple of years, from the Middle East, from Syria, from Afghanistan, from Iraq, and so on and so forth. But also, as the years have moved on, I think more and more we see a more mixed sort of synthesis of nationalities, including people from Africa and more especially from North Africa. So these are the nationalities that normally one would have associated with the people that are going to be or were going to be removed at large numbers. But this is not the case. According to the official statistics of the official data of Eurostat, the two nationalities that are being returned from the European Union with the largest groups of nationalities, both in absolute numbers and as a percentage, are Ukrainians and Albanians. And when it comes to Greece, Albanians constitute more than 80% of the total amount of people that are being returned on an annual basis. So this is one, I think, key point to keep in mind, why the European Commission has thought of a new way of dealing with returns. The other issue that is quite alarming and quite concerning to us has to do with the fact that we have been witnessing an increase of the time of people of administrative detention, of people being detained administratively. In fact, in Greece, I will give you some figures that relate to Greece. Again, we have an annual increase of people being kept in detention, and that unfortunately for much longer than 6 months. In fact, under the most recent amendments to the relevant Greek legislation, this detention could last up to 18 times 2 months, which is extraordinary, because it is even higher than what our constitution and our criminal sort of procedural law prescribes for people who are being detained on grounds of criminal charges. Unfortunately, this is the case at present. And in fact, we have, although we have witnessed a significant increase of people being administratively detained, we have also noticed a sharp decrease in the percentage of people that are being returned, which means that one would have expected that this would go in parallel. There would be some sort of a proportionality. The more people you are detaining, the more people you are able to, or you are detaining them because you want to return them, to remove them. But this is unfortunately not the case, or at least the official data do not corroborate such a scenario. These are the two concerns, and that I think are very striking as to the actual state of affairs when it comes to return operations just before perhaps the most recent Frontex regulation. Now, it has been mentioned by both Mariana and Jane that with the 2019 new regulation, there has been the focus has turned to to reinforcing the capacity of Frontex, both in terms of additional competences, but also crucially of staff and budget. It is true. It is a matter of fact. We are waiting to see how the regulation will play out. Indeed, as Mariana mentioned, most of the parts of the regulation are still not fully implemented, so we don't really know exactly whether and in which way the regulation will actually be effective or not in its sort of very ambitious goals. I just want to make a comment here, however, when it comes to the regulation, the 2019 regulation, because just prior to the last European parliamentary elections, both myself as the Greek Ombudsman and a number of my colleagues, my peers, were, if I may put it this way, we were lobbying to the appropriate bodies of the European Union in order to have a say on the drafting, on the wording, and on the provisions that would constitute the new Frontex framework, legislative framework, but also the recast return directive. We were, I must say, surprised, taken by surprise, to realize that the regulation was indeed passed through the various EU bodies as the normal procedure, the ordinary procedure prescribes, even before we had a new Commission collegium. I just want to share with you that if you may remember that the regulation was indeed agreed upon. The Frontex regulation was agreed upon before we had the confirmation of the new commissioners of the European Commission after the most recent European elections, which was quite odd and quite striking to us. So there was indeed an urgency on the part of the bodies that have drafted the regulation to get it through as quickly as possible, as swiftly as possible, and without much discussion or debate on it. And I note also that they opted again for the instrument of regulation rather than something more flexible that also member states could work upon. Now, I will turn now into the monitoring part of it, the monitoring aspect of it. I think both Mariana and Jane mentioned that when it comes to Frontex operations, Frontex coordinated operations, the 2016 regulation stipulated, envisaged a so-called EU pool of monitors. The same has been maintained in the 2019 regulation with a notable change that I will be referring to. Now, the idea was that national monitoring authorities would contribute trained monitors, in order to compensate for those countries that did not have a monitoring authority. For example, Germany. You may know, I think it was in one of Jane's slides, it was quite notable that Germany is the country that conducts most return operations in the European Union. Although this is the case, Germany does not feel that it has to have a monitoring authority of its own. It has a variety of bodies that are involved in return operations, but not a monitoring authority as such. I just use the example of Germany to highlight what exactly the pool of monitors does. So whenever Germany, for instance, wants to do a return operation, and according to the return directive, effective monitoring has to be in place. we are invited, we as members of the pool of monitors, we are invited by Frontex to state our availability to participate as monitors for an operation that will involve a return from Germany to a third country. It is not very clear to us, who are members of the pool, on what grounds the selection is made. This is one point that we have been raising with Frontex itself, with the executive director, in fact. But the thing is that I'll give you again some data which are quite interesting, and I think they will lead me to my actual point. In 2019, we had 80 operations conducted by Frontex. And in those 80 operations that I will be referring to, we had 90% of them being monitored by institutions, national institutions that were NGOs or state authorities. I think the case, Mariana focused a lot on the case of Hungary. In Hungary, the monitoring authority is the prosecution, is the prosecutor's office. Only 10% of those operations were actually monitored by bodies such as the one that I represent. That means Ombudsman or national preventive mechanisms. So bodies that have the additional, let's say, if I may put it this way, credentials of being an independent authority. Now, this has led us meaning Ombudsman institutions and NPMs, to start considering that something is not really working in the way that we would have wanted it to be, and with sort of the standard that we would feel at ease. If one looks at the list of monitoring authorities across the European Union, one notices that perhaps most of them, and the ones that are also involved in sorry, the EU pool of monitors, most of them are NGOs, so private law entities, or sorry, state authorities, state bodies, as I mentioned. There are several instances where, in fact, a specific branch of the police has been entrusted with monitoring return operations, so the police monitoring itself, the police. And also we have had, as I mentioned, the cases like, for instance, Hungary, where a prosecutor's office has been entrusted with such monitoring mandate. The problem here lies, what we think one of the problems when it comes to monitoring has to do with the independence of monitors vis-a-vis those that are being monitored, so the escorts and the authorities that they represent, but also Frontex that is coordinating the operations when it comes to Frontex coordinated operations. And that's why we feel that, for instance, there has to be a clear distinction between independent monitors and monitors who may be representing other types of bodies. It was mentioned that in the most recent regulation, there is a provision for additional staff, not only as border guards, roughly 10,000, I think, but also there will be, and I think there is a call already, there is a call which is now up for 40 monitors that will be Frontex employees. These people will be included in the same pool of monitors as members of my staff, so my monitoring team, the monitoring team of the Italian NPM, the monitoring team of the Slovenian Ombudsman, and so on and so forth. So this, to us, again, presents another challenge in the sense that we never felt very comfortable within the pool of monitors. We never felt that the way that the pool of monitors was designed, was set up, ensured appropriate and effective monitoring, and by effective, we understand that it has to be also independent. However, now there is an even more, the challenge has to do with the blurring of the different roles, in the sense that the new regulation somehow internalizes what is supposed to be an external mechanism of monitoring Frontex operations. So we now have within the same pool staff officers of Frontex monitoring Frontex, and also people representing independent authorities or private law entities, which are contractually which are contractually employed by Frontex to do the monitoring. This is a bit bizarre to us. This is a bit blurry to us. We don't see how exactly this. There are no clear rules as to who is accountable to whom. I think it was mentioned earlier. I saw one of the slides. I think it was Mariana's, about disciplining of escorts. The same applies when it comes to disciplining of monitors. We don't really know who is responsible for the performance of monitors. Suffice it to say that whenever there is a monitoring operation, the monitors are supposed to be drafting a report of the operation and ticking several boxes in a very long form that they have to use in order to make sure that all the procedures have been respected and have been followed. But this report is not shared with the people who employ those monitors, for example, with me. These reports are only submitted to the executive director of Frontex and to FRO. And nobody really knows what happens to these reports. There is no feedback. Whenever we have been witnesses of wrongdoing in certain operations, and we have reported on such wrongdoings on the part of the escorts, we have not received any feedback as to whether any sort of disciplining has been, any disciplinary proceeding has been instigated, or if what exactly the Frontex people have done in order to improve the operations. What we do receive is every 6 months a general report from FRO, which I think is not all public, it's not made public, it's not published to everyone. It's somehow semi-confidential, so it's shared with the people who are working with Frontex and also with the advisory board, of course, but it's not made public to the wider public, right? To all those concerned and all those who may be interested in the findings. These are some of the concerns that we have had in the course of the last years, which have led us to, and I will conclude with that, which have led us to consider that something is missing here. We need to have a proper mechanism, a monitoring mechanism that would be independent from Frontex, that would have the assurances of independent institutions. So the sort of the legal framework, operating within a legal framework of an independent institution. And this is why we have tried to work together with my peers. We are now already 12 institutions that are involved in monitoring operations in Europe, including the Slovenian, the Slovak Ombudsman, the Italian NPM. Many of you may not know, but the Italian, in Italy, there is no national ombudsman. There are only regional ombudsmen. So we have been working with the Italian NPM, who is nationally operating. And we have also been working closely with the Spanish ombudsman and with a number of other ombudsmen across Europe who are involved in monitoring operations in order to set up what we consider to be the actual monitoring mechanism, external monitoring mechanism that is needed and is missing at present from the way that Frontex coordinated operations are conducted. We are hoping to be able to start a pilot program at present in order to demonstrate the difference between having an independent mechanism conducting monitoring as opposed to having internal monitoring procedures and bodies. I'm not arguing against internal monitoring procedures and bodies. I think they are quite important. I think they have to be there. I think they're essential, but they're not sufficient. So we need to have both internal bodies. So I'm all for the increase of Frontex staff when it comes to monitoring, but I do believe also that this does not suffice in order to demonstrate that Frontex operations are truly transparent and truly respecting both the principle of legality and fundamental rights and liberties of the people who are being returned, most notably their fundamental right to decency and decent treatment. I hope that in the course of the next few months, we will be able to, and we are working towards that, where we will be able to convince the various EU bodies to introduce one word into the recast returns directive, one word which would mean a whole lot. It would completely change the way that monitoring is conducted, alongside the provision that stipulates that monitoring has to be effective. I think I mentioned it earlier. We would like to introduce also the word independent. So by having the word independent alongside the word effective, this means that more attention will be paid on the actual status of monitoring bodies that are entrusted with monitoring human rights, observance of human rights and fundamental freedoms of people who are being included in such operations. I will leave it to this point because I understand that normally there is a very interesting debate that ensues. So thank you very much.
Thanks very much, Andreas. That was very interesting, and I think it makes clear some of the issues, for example, with the political context for removal operations, given that Albania and Ukraine are some of the most common destinations. In that regard, it's interesting, which has been reasserted again in the pact, is that the Commission would like some member states to use their historical relationships with certain countries, i.e. a history of colonialism, to increase cooperation with them on removals and readmission. We are about to come up to time, but hopefully our speakers can stick around for a few more minutes so we can fit in some questions and discussion. We do have some things I would like to ask the panel. So I'll just go back to a couple of early questions we had. One which was for Jane, which was, you mentioned a proposed database for people receiving, I think, or undergoing voluntary return proceedings. And Zachary Goldberg asked, how would this proposed database be different from Eurodac?
Thanks. Yes, that is a great question, and I'll try to answer it quickly. So the very short answer is we're not quite sure. This is because this common database is mentioned in a list of sort of member state suggestions of things that they would find helpful from Frontex. And this is in a council document that we have had access to, but have not yet been able to publish. So you can look forward to publication shortly, where you'll be able to see a summary of member state responses to certain questions about Frontex involvement in returns and what would be most helpful. So yeah, while there's no kind of actual detail available about what data that would involve, like what data could be processed as part of that, I would imagine it being more to do with perhaps like follow up on information about remigration, or perhaps like Frontex's own intelligence and research, so driving the more policy side of its involvement in operations. But obviously that at this point is more speculation than hard fact.
Thanks, Jane. Yeah, on the point of transparency, actually, Andreas mentioned the Fundamental Rights Office's report on its monitoring work of forced removal operations, which is not really public. Thanks to Statewatch's long-standing commitment to transparency, if you go to our news page on our website, you can find the most recent report of Frontex's Fundamental Rights Office, along with the agency's own report on operations in the first half of 2020, with some rather concerning findings from the Fundamental Rights Office, in fact. Which brings me to a question from Marta Dionco from Pickham, who asked to Mariana, but I think this question goes to Mariana and Andreas as well. You mentioned in your recommendations more transparency, and could you please elaborate on some ideas how this could be implemented in practice? What might this mean?
Should I go first, Mariana? Okay, sure. Well, one of the things that we are working on, and one of the actual ideas that we are going to actually put in place to implement, is that we are going to set up a common website. All of the 12 institutions that we are supporting this drive for setting up an independent monitoring mechanism to conduct Frontex coordinated forced return operations monitoring. We are going to set up this website in order to share our actual reports with people, with everyone. There's nothing. Well, the way that we have read and we have analyzed the existing sort of legislation on the subject matter, there's nothing to prevent such a thing from happening. Truly, it is a matter of choice, and the choice that was at least the way that the Frontex has been operating clearly is not as transparent as we would have wanted it to be. They're not sharing their information, or they're not sharing them in the detail or in the timely fashion that we would have wanted them to. So we are hoping to come in and somehow remedy this. We will be publishing in our website the reports of our monitors, plus the general findings and recommendations, in order to, especially with a view to streamlining, to producing uniform standards for the treatment of people, because we have been witnessing and we have been reporting different standards when it comes to the monitoring, both monitoring but also the treatment of people who are being returned, depending on the country that is actually organizing the return operation, which is clearly not acceptable for a member state of the European Union. So we will be sharing, that's one of the things that we would like to do, we will be sharing all of our work and all of our findings.
Perfect. Yeah, I thought it would be best for someone who deals with these issues in practice to speak about first. So we have to recognize that there have been improvements in the agency's transparency, especially since 2011. The agency then updated their website and had a lot of information on the website. They started issuing more detailed reports with very much a lot of information about their operations. That's where also most of the data for the report have been found. However, in the last couple of years, we see several steps back by the agency in terms of transparency. I think the question was about the measures that need to be taken in new legislation. That would not be necessary. We have the access to documents regulation, and the enforcement of that regulation, enforcing the obligations under that regulation would be enough. But we see that we have a lot of access to documents requests being denied, and most of them being given only partial access, with most of the relevant information being denied. Also, last year, I think, Frontex introduced a new platform, a new system for requesting information that makes it very restrictive, and also claims to have intellectual rights over the information it shares, which prevents the person that asks for the information to share it more generally, even though we're talking about public documents. So it is things like that can be still improved in terms of communication. And also a lot of the information that was there in the website has now been removed. For example, information regarding the data of each operation, and the links also keep moving, which makes in practice very difficult to follow the work of the agency, at least what they report about it.
Thanks, Mariana. I can also add on that point that Statewatch, well, not so recently, submitted a complaint to the European Ombudsman about Frontex's failure to maintain and keep a public register of documents, which is one of the requirements under EU access to documents law. And recently the Ombudsman made a proposal to the agency, which responded with an action plan to implement a more comprehensive register. So we're going to see over the next couple of years what exactly that means in practice. We are about 7 minutes over time. I will ask one more question from our attendees. Sorry for not getting to all of those. I should also add, feel free to write to us at Statewatch, and we will pass your questions on to our speakers, and if they can, I'm sure they'll respond. But I think there's just something worth clarifying. I had a question from Ilaria Aversa while you were talking, Mariana, who said, with an increase of responsibility, will Frontex be able to override member states' particular migration policies? Specifically, would they be able to mandate deportation, even if the member states would not mandate one under domestic regulation?
Sorry. Yeah, that is a complicated question. The first answer should be no. So the Frontex cannot mandate policy. Frontex only follows it, only implements it, only enforces it. But the more specific question then, what would happen if the member state does not want to return? Does not want to return a person? Can the agency do so on its own? Again, the first answer is no. The agency would only prepare the return decisions, will not be able to adopt it. However, those that practice law in Greece will perhaps have concerns similar to those that they had regarding the similar role that EASO has with respect to preparing the asylum decisions. There we saw that there have been reports from Greek and international NGOs that EASO turns out having a disproportionate influence upon the return decisions, also because of the incapacity of the Greek Asylum Service to deal with the overburdening of the service with all the requests, which makes the proposal, the suggestion, let's say, of the agency much more impactful. So we could expect that there could be such an influence. Now, in more general terms, so for the individual return decision, in more general terms, in terms of policy, the difference that we see in the 2019 regulation is, while in 2016 a return decision could be initiated by request of a member state or with the agency's own initiative, now since 2019 we do not have a request. The member states cannot request anymore as such directly. There will be a system, a rolling system, where the agency observes the returns needs of member states and will act accordingly without being prompted by the member state. Now, if we come to a situation that the member state does not want to cooperate and does not want to either surveil its borders or return persons, then that would be an extreme case. Then the EU, with the support of Frontex and the proposal of Frontex, has the power to intervene. That has been 2016 regulation and enhanced in the 2019 regulation. So basically, there can be measures imposed upon a member state that does not want to cooperate if it happens to have a policy against deportations or against surveillance of the borders. And that can result in Schengen-related problems for the member states, so sanctions such as closing Schengen borders. So this would be a more indirect, let's say, influence of the agency there.
Thanks, Mariana. So hopefully that's clear. But I think it also makes clear the general trajectory of things in the last few years is for more power, more powers to be granted to Frontex by the member states and by the Parliament. And I think, as our speakers have made clear, in the field of deportations and removals and readmission, along with everywhere else the agency operates, there is a need for ongoing scrutiny, more transparency from civil society, journalists, and official institutions such as Ombudsman. And I'm sure there'll be much more to do in the coming years as the Pact on Migration and Asylum is implemented and other developments arise. So on that note, we're going to finish here. Thanks to everyone who stayed with us over time. Many thanks to all our speakers. We have no more webinars planned in this series right now, but we will be continuing to work on Frontex, on other EU agencies, on other topical issues in the field of justice, home affairs and civil liberties. So sign up to a Statewatch mailing list, sign up to a TNI mailing list. They also do loads of great work in this area. If you're feeling wealthy at this time of year, feel free to throw us a donation, become a friend of Statewatch or support TNI. That would be very welcome. And yeah, thanks very much. And we will see you next time. Thanks for coming.
Thank you very much.
Everyone, thanks Chris for chairing.
Thank you.
Thank you.